This is cause number 213010786F style State of Texas versus Wasim Cabrera. Is that you, sir? And Mr. Bogan, do you waive arraignment and reading of the state's indictment?
I do, Your Honor.
Mr. Cabrera, can you read, write, and understand the English language? Are you a U.S. citizen? You understand that you have an absolute right to a trial. However, by entering into the deal with the state, you're waiving that right. Did you understand everything you signed? Go over everything you signed with your attorney. You've been charged by way of indictment with a second-degree felony offense, burglary by habitation. Second-degree felony carries a range of punishment of 2 to 20 years in the penitentiary. Knowing the range of punishment which you're charged with, how do you plead guilty or not guilty? Are you pleading guilty because you are guilty and no other reason?
Yes.
Anybody forcing you to do that? Anybody, do you understand what's going on here today? You understand what my role is? You understand your attorney's role? You understand what the state's role is, right? Okay, those two are the parties here. They represent prosecution, represent you, and who am I? Okay, you understand all that? Is there a recommendation from the state?
Yes, Judge. In exchange for the defendant's plea of guilty, we are offering 6 years deferred probation with restitution to Linda Towns of $25,000. We are recommending that he be on the mental health caseload with probation officer Haley Workman, that he receives a substance abuse evaluation inside of 60 days, that a TRAS is completed inside of 45 days, and that he has curfew from 10 p.m. He is not to be out of his house after 10 p.m. He is not to leave his house before 6 a.m. unless prior proof of work and or school has been provided to Ms. Workman. I believe that is what we're recommending.
Is that your understanding of the state's offer? And you understand by accepting that offer, you're waiving your right to appeal. You'll have no right of appeal. Anything from the state?
Yes, Judge, will offer states one defendant's judicial confession, stipulation of evidence, states two, Article 3914.
No objections.
States 1 and 2 will be admitted.
Rest in close.
Both sides have been arrested and closed. I will find the evidence sufficient to find you guilty. I will defer finding you guilty. Place you on community supervision for a period of 6 years. There will be court costs and you will have the restitution. You understand that? And the victim is aware of all of that too.
Yes, Judge, we have spoken with Ms. Towns and she is aware of the restitution.
Okay. You understand that goes to the victim. You understand? And so I do expect for that to be paid. And I know the state has put a lot of other conditions on you as far as your mental health caseload. You understand? So we're going to give you the resources to get whatever it is that you need to do to get better and to understand those things. But if you fail to use those, how old are you? 17 years old. All right. You got your whole life in front of you. You screw those things up, you'll be a convicted felon the rest of your life, no matter what. On top of going to the penitentiary. Right? It won't be here in Kaufman County Jail. It'll be down in the pen. You understand that? This is your one and only chance. Right? You need to either fix those things. At 17 years old, you need to grow up, fix those things, and make sure you follow all those conditions they put in there. You understand? If you don't, they're going to let me know. All right? They're going to file a motion to revoke you off that probation. When they file that, I'm telling you, that's what's going to happen. Right? You got to follow all those conditions. And if you screw up and you don't follow those conditions, you understand you're still looking at that full range of punishment, 2 to 20 years. And that not only on top of that being a convicted felon. So it's up to you. Right? I understand, we've had you evaluated, all those things, but it's going to be really up to you. You've got to figure it out. We'll give you all the tools and resources you need to do that. If you're not keeping up with Ms. Workman, that'd be your probation officer. You understand that? She does all the mental health caseload. She has everything she needs. She's already been told by both the state and myself. If you don't do that, you will be right back here, and you won't be staying here. Okay? You understand? You will go to the pen. All right, you got any questions for me? All right. All right. Make sure you follow those. I already sent it. Yeah.
Yes.
All right, we're off the record.
And then the only other thing I have, Your Honor, is a motion to hold bond insufficient for Sarah Fisher. She's in the hallway.
I think it's
Okay. What's
And she was drug tested today, tested positive for opiates. So I
so you don't have much of a case?
It's a foregone.
Do I need to bring Courtney out? Or-
Yeah, let's just bring her out and put her on real quick so that we can put on the record.
Okay, so you're rather than the bid.
I'm getting my client.
What's going on? I'm good. You all right? No, you're fine.
I
You're
haven't
fine.
signed anything yet. I just want to approach it.
Oh, that's fine.
How are you?
It's a busy day.
How are you doing, Mr. Moore?
I'm hanging in there, trying to keep up with the judge.
So we're just getting the phone records on there.
Yes, sir.
We have the phone already?
No, sir.
Okay.
I would just have the number. A lot of statements, evidence of vehicle, whatever it matches. Really, I had some good evidence to retrieve some threatening messages from my ex.
Gotcha.
But apparently she got a new phone, lost it, so they kind of went away. So it's kind of my only chance to try to put it in one spot. He's identified the vehicle that he drives and whatnot.
Where's it all true and correct? She signed that one for me. And there's search warrant back.
Thank you very much.
No problem. Just let me know if you need anything else.
Yes, sir. Thank you very much. You have a good day.
All right, see you.
I'll get your copies too. All right.
Heather, as soon as Joseph gets done going over that, we'll do that other one.
Make copies.
You know, just lost Joseph.
He's getting visited by other probation officers.
Think so. Well, I didn't work on the last one. I'm a little more hands-on now. Because the last chief didn't work it. All right, let's do the other one. Come on up. All right, let's go on the record. This is cause number 206004486F. Oh, I'm sorry. All right. This is cause number 201109786F21100058 86F21100059 All style state of Texas versus Sarah Fisher. Ms. Fisher, you charged with, I believe these are all state jails, sir.
They're all state jails.
These state jail felony offense cases. You were given conditions of bond, and it's my understanding that the state has filed a motion to hold that bond insufficient. You understand that?
I'm not sure that my client was actually given conditions of bond when she bonded out. Just correction to the record.
All right. All right. Would you like to call your witness?
Yes, Judge. We'll talk about it.
Please raise your right hand. Do you solemnly swear the testimony you're about to give in this case be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Please lower your hand. You may proceed.
State your name for the record, Courtney Watson, and I will return to you. I'm the court officer for the Coffee County Probation. And you are familiar with Sarah Fisher's court today. And I was on vacation last week, but you recall that I asked you to consider asking Ms. Fisher to submit to your analysis on last Thursday. And while I'm not here, did you meet with Ms. Fisher and give her an opportunity to provide you? I did. And you understand that she is on bond, right? And that she is not to be using drugs on bond. Right. And that there was some concern that perhaps she was using drugs on bond. We were trying to get to the bottom of that. That is good. And what happened, this is when to the judge last Thursday when you met with Ms. Fisher?
Last Thursday, I met with her in the hallway to ask if she could submit to a drug test. If she was ready to provide a sample. She said yes. I asked if it would be clean, and she said no. I didn't actually do the drug test because she admitted it to others.
And so you said that she would use this. Did what other explanation did she give you in regards to that?
I asked if it was heroin or pills, and she said it was hydrocodone.
So she said it was not prescribed. So you wound up not seeing the UA because she admitted used to be,
Yes.
she should not use. Correct. And then today, a week later, we are in court here on motion for bond insufficient in part because of what happened last Thursday, correct? Correct. And then also sort of dovetailing on what occurred today.
Yes.
Okay, and explain to the judge what happened today when you asked Ms. Fisher to submit.
I took her down to the bathroom. She was able to provide a sample, and it was positive for morphine and negative for methadone. She stated that she was taking methadone, but the urinalysis was negative.
So methadone would be considered a MAT or medically assisted treatment that Ms. Fisher may be engaging in to try to help. Correct. And however, despite her stating that she has been on methadone, the test was negative.
The test was negative.
But it did test positive for morphine, is that correct?
That is correct.
And that is a breakdown of heroin in your experience.
Yes.
So do you believe that there is strong possibility that based on viewing that in front of you, that she's actively using the drug?
Absolutely.
have no questions for this witness.
Brett?
Who was?
All right. I mean, obviously you can't be tested positive, you understand that? Simple as that. You understand if you need help, you can provide that. But obviously, you're not going to get that while you're out doing the same things you've always been doing. So I am going to grant the motion to hold the bond insufficient. You will be taken into custody. You understand it's up to you whether or not you want to use that help. There are a wide array of programs that we have that can get you off this stuff, get you back going on the straight and narrow. But until I force you, that's what's going to happen. So that's what I'm going to do. All right, we're off the record.
Just for your knowledge, she did complete an application for the drug court today, which is now turned in downstairs to Wanda Rodriguez. And that's within the coming week and a half to 2 weeks. We'll have an answer for whether or not she's approved.
Sounds good.
And let Officer Wayland and Officer Worth, I know that she's applying.
Good. We don't get her a tissue, please, from somebody. I'm good. Not causing trouble, right? Was it a moment or something before that? Fine, you know. So you're right. You need to try to get in the drug court, figure those things out, and you'll have all the resources you need to figure it out. All right. Davina Rogers. Sure. All right, this is cause number 206004486F. Styled State of Texas versus Davina Rogers. Is that you? Mr. Russell, do you waive arraignment reading of the state's indictment?
I do.
Ms. Rogers, can you read, write, and understand the English language?
Sir.
Are you a U.S. citizen?
Sir.
You understand that you have an absolute right to a trial in this case for the whole case on your guilt and innocence, but by entering into this deal, you're waiving that right. You understand?
Yes, sir.
The charge by way of indictment with the second-degree felony offense of injury to a child, elderly, or disabled. Second-degree felony carries a range of punishment. The punishment you're looking at is 2 to 20 years in institutional eviction. You understand that?
Yes, sir.
Is there anything from the state?
The state of state is even number one, defendant's voluntary silence stipulation and consolidation.
No objection.
States 1 will be admitted. So States 1 is now admitted. Do you understand that?
Yes, sir.
And what we are doing is we're setting this case for what is essentially called a slow plea. You understand?
Yes, sir.
Pleading
Guilty.
guilty, and then you're going to a jury for punishment. You understand?
Yes, sir.
So you know the range of punishment.
Yes, sir.
You know what you're charged with. Is that right?
Yes.
And you also are pleading guilty to this offense. Is that correct?
Yes.
All right. We will get this set.
It's set, Your Honor.
Okay.
September 13th, I believe.
Sounds good. All right. We'll make sure. We might can play around with that since it's just a punishment portion. So I'll talk to you on. I ain't putting it on a regular document. It's going to go. But I'll see if I can find y'all a date.
Okay. I mean, you understand, we're going to do the jury.
I know,
Okay,
but still, it won't take us
gotcha.
a day and a half to do, right?
I would say guilty to
So,
Okay.
otherwise we'll be, well, I'll let y'all know. Let me talk to him, let me see it. But, State 1 is submitted, she has to get the right for it.
Want us to come talk to you?
No, I'll look
Okay.
at the docket and I may come chat with y'all.
Okay.
Because that day, I'm sure there's other stuff to happen, so,
There are.
yeah. So I may put it on.
I'm listening.
Are you set that day too? In custody? Well, let me look at my docket. I may try to move things around, or I may let Judge Chitty come help me out for a couple of stuff that we know for sure are going.
Okay.
Because he has volunteered to help.
Okay.
the case with Jose, which I think Sunny has said is number two. I'm also, so we can figure out. We can just not have it set.
You can't have more than one case set today.
All right, I'm saying I can't. I can't. I'm trying to say is that if we're gonna find a date that if Judge Chitty's gonna hear something and you're gonna hear something.
Oh, yeah, yeah. Oh, I got you. Yeah, absolutely. I would not, yeah, I'm not gonna do that. That would be, that would be awfully hard. Yes.
What is the hour-long recess?
Yeah. Don't worry. I'll make sure that doesn't. All right, Katrina Majors. That, hey, I've had, I've never done simultaneous. Now, we've had them in the hallway,
Right.
in the box, and in the, jury room, but that would be impressive if you could do it simultaneous.
You like reading two books at once.
I've seen
That-
David Burrows pick a jury and take a.
No, he has done that. Yeah, he's one of the ones that, he'll try 3 a week,
Yeah.
and it's formulaic. Very, very good. All right, this is cause number 18-303-8186F, Styled State of Texas versus Katrina Majors. That's you, ma'am? Ms. Noriega, you waive arraignment and reading of the state's indictment?
I do, Your Honor.
And Ms. Majors, can you read, write, and understand the English language? You're a U.S. citizen. You understand that you have an absolute right to a hearing before the court on the state's motion. However, by entering into the deal with the state, you're waiving that right. Do you understand? I'm sorry, is this a new case?
It's a new case.
I'm sorry. You have an absolute right to a trial. Just a year through me. But it looks like there were some issues there. All right. You have an absolute right to a trial in this case, but by entering into the deal with the state, you're waiving that right. Do you understand everything you signed? Did you go over everything you signed with your attorney? You've been charged by way of indictment, state jail felony offense of theft. State jail felony carries a range of punishment from 6 months to 2 years in the state jail division. Knowing the range of punishment and what you're charged with, how do you plead guilty or not guilty? You plead guilty because you are in fact guilty and no other reason. Is anybody forcing you to do that? Is there a recommendation from the state?
Yes, Your Honor. In exchange for the guilty plea, the state is recommending 1 year probated for 3 years, $750 fine, court cost, and restitution in the amount of $4,155.32.
Is that your understanding of the state's offer? You understand by accepting that offer, you're waiving your right to appeal. You have no right of appeal.
Yes.
Anything from the state?
State offer states 1 is not stipulation of evidence.
No objection.
It states 2, showing that the state is in compliance with Article 3914 of the Code of Criminal Procedure.
States 1 and 2 will be agreed.
Thank you. We rest.
Can I call it?
Please raise your right hand. You solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God. Please lower your hand.
Katrina, the same name.
Katrina, you understand that this is correct?
Yes.
And you understand that the reason why we did it, we did is to get the constitution.
Correct.
And you understand this, so
Yes.
you understand that there's a lot of money.
Yes.
And there's that problem with that. Where is that?
Yes.
No question.
Both sides having the rest of them closed, I will find the evidence sufficient to find you guilty. We'll find you guilty. Sentence you to 1 year in the state jail division. However, that'll be probated, placed on community supervision for a period of 3 years. There'll be a $750 fine, court cost, and the restitution to the victim. You understand that?
Yes.
All right. And did you go over the conditions of probation with your attorney?
Yes.
I know he told you that if you violate any of those conditions, you can be revoked and still sentenced up to a year in jail. You understand?
Yes.
All right. Make sure you follow those, all right?
Yes.
All right. Step right over there. Don't even ask you. There you go.
Generally, it's a bit harassing.
All right, Chauncey Holman. This one will need to be